Hello, viewers and students, friends. This is Dr. Kashinath Neharkar. I welcome you in my YouTube channel, Law Education Volunteer Dr. Kashinath Neharkar, at lecture series on property laws. Friends, in this lecture, we are going to discuss very important concept under property law, and that is concept of attestation. But before that, friends, if you have not subscribed this channel, please subscribe this and please click bell icon to receive further notifications from this channel. So friends, let's start with the concept of attestation. Say friends, attestation is very important concept for the Transfer of Property Act. Friends, we know the basic object of Transfer of Property Act is to provide mechanism, to provide the rules, to provide the regulation, or to provide the process for transfer of property from one living person to another living person without keeping any chance for future dispute. So the property should be transferred in very smooth way. That is the basic object of Transfer of Property Act 1882. So for that purpose, that process includes many things. One activity in that process is the attestation. Afterwards we are going to discuss what is the transfer of property process, what is the act, etc. But before that we are going to discuss what is the process of attestation. It is very important process. So friends, we must understand what is the concept of attestation. See, the term attestation is nothing but the derivation of word attested in everyday life, or while in education, etc., or for submission of forms. We have to submit our documents, xerox copies of documents, and for that purpose we used to submit attested documents, etc. So what is the reason to attest that documents? Reason is nothing but to confirm, to certify the originality of that documents. So the same process is here also. So the term attestation is derived from attested word. See, therefore we must understand what is concept of to attest. So to attest means to testify a fact or to bear a witness to fact, whatever the thing that is happening in front of you. If you are the witness, you must witness the thing that has happened before you, and whenever there is any question regarding happening, non-happening of such thing, you must have give a witness there as a witness. So the witnessing the thing is nothing but the attesting. But again we are going to discuss that in detail here. See, it means we must understand the concept of attestation in the context of Transfer of Property Act. So the transaction is happening before the witness is the transaction of transfer of property. One person is going to transfer that property to another person. So this transaction should be witnessed by third person, by which in future if any dispute arises, the third person will say whether the transaction was happened or not. So he's witnessing that, he's witnessing the fact. So it means the to sign and witness the fact of execution of document by executant. So attestation is necessary to see that whether particular document which covers the transfer transaction is executed by parties or not. That has to be seen by that witness. This is the attestation. See, so the attestation in relation to document signifies the fact of authentication of document, signature of executant, then signature of parties, etc. So because, as I have already told you, the basic object of Transfer of Property Act is to provide the process for smooth transfer of property between two living persons without keeping any chance for future dispute. So in future the parties who have actually executed the document, that party may deny that he has not executed. At that time the witness will be there to prove whether he has executed it or not. Execution is nothing but the signing of the document. See friends, so the attestation is necessary to confirm the authenticity of document, authenticity of executant signing the thing. So we must see what is the object of attestation. Friends, basically an attestation of document ensures the authenticity or truthfulness of execution of document, because the transaction is in between two person, but when third person, third impartial person see that document is executed by two persons and then signs that document as a witness, in such circumstances when any dispute arises in the future, the third person can be called to testify the truthfulness of that transaction. Therefore, basic object is to ensure the authenticity or truthfulness of execution of document. And the attestation has basically two objects. The first object is to confirm that particular document is entered by parties themselves, and that is signed by the signature, signed by the parties themselves only. The parties are called as executant, the parties who execute that document, the parties who prepare that document and who sign it. This is called as execution. And second object is that the parties has entered into transaction, parties has signed that document without any kind of unlawful influence, fraud, coercion, etc. So that is the reason why, for the truthfulness to authenticate the documents transaction, the witnessing of the transaction is necessary, and the witnessing of that transaction is nothing but the attestation. So the attestation is nothing but the process to witness. Attestation is nothing but a process to witness a particular transaction by third person, whosoever the person acts as a attesting witness. So friends, now we must see what is the definition of attestation. The Transfer of Property Act provides section 3, which provides definition, and accordingly this section does not define what the exact meaning of attested or attestation, but it just provides the circumstances when it is understood that particular document is attested. So we must understand what are those circumstances where a document is called to be attested. So generally the attestation is nothing but testifying the signature of maker. It means witnessing the signature of maker. Then by person who see it, who witness it, who testify it, he again signs it, that signs that document. So this is the process of attestation. So as you know, the general procedure of transfer of property is that that transaction is completed through written document. That document is nothing but the contract consisting terms and conditions regulating transfer of property, how that property will be transferred from one person to another person. Then once that document is prepared, then that document will be called as an instrument. That document will be firstly executed by both the parties, transferor and transferee. It means both parties will sign that document. Then the person transferring that property must be signed, then other party should sign, and lastly witnesses should put their signature. So this is the process of witnessing. So this is, now we must see who can act as a witness, who can act as a witness. See, according to the provisions of act, any two persons who are age of majority and possess sound mind can act as a witness. So here also the competency of witnesses is provided. So minimum number of witnesses that are required for attestation is 2, and such person must be major, such person must be sound mind, etc. Therefore, since it is very important, the attestation is very important, so it should be completed, it should be done by the person possessing following qualification. And this qualification is that attesting person, the person who is going to act as an attester, must be major person, He must be a person of sound mind. It means he should not be idiot, unsound mind person, etc. Then that person may be literate or illiterate, because he must see the execution of document. It is not necessary that attester should always be literate. If he is literate, it's okay, but he is not, you can take the thumb impression of that person as a attester. Then the next qualification is that the party to deed should not attest. It means the parties who are parties to that transaction, parties to that deed, they cannot act as a witness, because in future if any dispute arises, their witness cannot be taken, their evidence cannot be accepted as a attesting witness, therefore they shall not act. So attestation by parties to that transaction is not a valid transaction. Then sub-registrar of stamp duties, he also cannot act as a witness, attesting witness or attester. Now this is the qualification we have seen. Now we must see what are the essentials of valid attestation. So for the transfer of property transaction, that document through which the property is going to be transferred, that must be properly attested. So for valid attestation, certain conditions must be satisfied. We must see what are these conditions. The first condition is that attestation by two or more person is necessary. It means the attestation by a single person is not valid. So minimum number of attester or the persons required for attestation is 2. Then attestation by single person is not valid. Then what the person who is acting as attester, he must do certain things. Among these things, first thing is he must see the parties, that is executants signing that document and imposing their thumb impression on that document. It means executant means nothing but those parties who are transferor and transferees directly. Then he must see, he must get knowledge from both parties, that what is the transaction, etc., or these are the signatures of both parties, etc. He can take that information also. And lastly, each attesting witness must put their signature on that document. So this is attesting process. Regarding that, the question is whether the parties to that transaction should sign the document in front of witnesses or anything else. So this question is solved by the Supreme Court in High Court in Avinash Chandra versus Dashrath, where the court held that not only executant should sign in the presence of witnesses, but the witnesses too sign it in presence of executant. So for valid attestation, the instrument, which is the document that covers transfer of property, must be signed by parties in presence of witnesses, as well as witnesses must sign that document in presence of parties. So that will ensure the validity of that transaction. Now we must see what is the form of attestation. What is the form through which that attestation shall be completed? See, actually the Act does not provide any specific form of attestation, how that attestation shall be made, or where parties shall sign, attesting witness shall sign the document. Such a form is not provided, but the signature of attesting witness on that document is sufficient. Attesting witness, at least 2 attesting witness, that is sufficient. So there should be the signature of both witnesses on the document. The signature need not be at any specific part or place. At any place the parties can sign. It means the witnesses can sign that document, but generally it is made at the end of document. So when that document, what the terms and condition, etc., that are concluded, then there are parties signatures, executant signature. After that the witnesses can sign. So this is the general thing we can follow, but most important is that witnessing the fact that parties have, the transferring parties have signed the document, that is signed voluntarily without any influence, etc., and this has to be witnessed by third parties, third and fourth parties. So this is the process of witnessing. This is process of attestation. So where the witness is illiterate, then his thumb mark can be taken on that document. So friends, this is very important topic under Transfer of Property Act, because without valid attestation the transaction cannot be held as a valid transaction, or the further process of that transaction cannot be completed. So friends, if you like this video, please share it with your friends, and do not forget to subscribe my channel, and please click bell icon to receive further notifications from my channel. So friends, thank you.